Good morning, good afternoon, good evening, wherever you're at. It's Dr. Diane Sanchez, and we are going to discuss human resources management and equal employment opportunity. Our learning objectives today in this webcast is to identify the major government agencies that enforce employment discrimination laws, outline key provisions in the Civil Rights Act of 1964 and amended in 1991, show how women are affected by pay, job assignments, and career issues, distinguish between the two types of sexual harassment and explain how employers can prevent its occurrence, list key elements of disability discrimination laws, discuss the legal protections to prevent bias and discrimination based on age, religion, national origin, and other factors. So let's first start at the nature of equal employment opportunity. It is unlawful discrimination, making employment decisions on the basis of protected characteristics. And those are attributes about an individual that is protected under EEO laws and regulations. So things like your age and color, your disabilities, your genetic information and marital status in some states, military status and experience, national origin, pregnancy, race and religion, sexual orientation in some states and cities, such as San Francisco and California. Equal employment opportunity is EEO, employment that is not affected by illegal discrimination. So, what it says essentially, it requires employers to make status-blind employment decisions. That means emphasizes that differences among people should be ignored and that everyone should be treated equally. So, status-blind decisions are made without regard to applicants' personal characteristics, all the things we talked about, age, sex, race. That is important as part of the EEO law. Sources of regulation and enforcement: federal statutes enacted by the legislation, and state and city legislatures. I know California, New Jersey, New York have very strict enforcement. San Francisco has just had enforcements on gay and lesbian rights. So not only do we have a federal law, but we also have enforcement in the state and city legislations. The courts have given us basically guidance. When a law becomes effective, most courts really teach us the direction that law should take. So, for example, when Obamacare came to the Supreme Court, the court's guidance was that was a legal law because it was a tax. So courts give us real good guidance on how we are to interpret the law. And that's what it says. It rules on many cases. And we'll talk about a lot of cases. Sources of regulation and enforcement: government agencies issue guidance, like the Department of Labor. Many of our agencies give us guidance on how we should implement the law. The Equal Employment Opportunity Commission enforces employment laws for employers. The Department of Labor oversees compliance with employment-related laws. So let's jump into some theories. Okay, there is theories of unlawful discrimination. Disparate treatment. Members of a group are treated differently from others. And so this is really knowing that you have done something wrong. Disparate treatment occurs when individuals with a particular characteristic are treated differently from others. This type of discrimination is typically overt and intentional and often follows a pattern and practice. So, for example, if only female applicants are asked interview questions regarding child care and male applicants are not, that is disparate treatment. All right, so we talked about the different standards. Same standards is used, but it's not related to an individual's job. In my example of child care, even if you asked of men, it doesn't have to do anything with the job. It's overt and intentional, as we talked about it. And the case that your book talks about is Riches and DiStefano, the case of the white firefighters in New Haven, Connecticut, being denied promotions because of their race. This demonstrated disparate treatment. So, a promotion examination administered to eligible firefighters resulted in lower pass rates for black candidates. So, this was really a very interesting case. You should read it and it'll give you a good sense of the disparate treatment. Now, disparate impact. Usually this is unintentional because it's got the same criteria, but it was unintentional. So members of a protected category are substantially unrepresented as a result of employment decisions that work to their disadvantage. And so for example, if you're giving a math tests, and you're requiring a certain percentage of right answers, well, that may have a disparate impact on maybe Hispanics and African Americans, because history has seen that the graduation rates are less than white counterparts. So if you make these kind of pass rates across the board, they may have a disparate impact on a protected class. So in the Griggs-Duke Power decision, the U.S. Supreme Court ruled that the lack of intent is not sufficient for an employer to prove that a practice is lawful. The court also stated that the employer has the burden to show that a selection practice is directly job-related as a business necessity. So, Griggs is about the firefighter test where women failed at a higher rate. The test was a true reflection of the job-related duty, carrying a person out of a burning building. Therefore, the test would be lawful, even though women would not pass at the same rate as men. All right, EEO concepts. This is the 4 areas that we must consider. Business necessity is a practice necessary for safe and efficient organizational operations, such as restricting employees from wearing garments that might get caught in machinery, although the attire may be required by an employee's religion. So business necessity has been the subject of numerous court cases. And you really need to prove that it is a business necessity and job relatedness. The bona fide occupation qualification, the BFOQ. Employers may discriminate on the basis of sex, religion, or national origin if the characteristics can be justified as a BFOQ. The example that comes to mind, and your book doesn't give you one, is that back in the 60s, nuclear power plants would not hire women of childbearing years. And their defense was the BFOQ, that the children of childbearing years would be affected in the nuclear power plant if they worked there long enough. It could affect the fetus, the unborn fetus, and directly affect a woman's ability to have a baby. So they did win that case, and they were able to prove that it was a legitimate reason why an employer can exclude a person which otherwise would be considered, illegal. Then the burden of proof. The burden of proof must be satisfied to file suit against an employer and establish unlawful discrimination. The plaintiff charging discrimination must establish the prima facie case through either factual or statistical evidence. The prima facie case means that sufficient evidence is provided to the court to support the case and allow the plaintiff to continue the claim. And then retaliatory practices. Employers are prohibited from retaliating against individuals who file discrimination charges. Retaliation occurs when employers take punitive action against individuals who exercise their legal right. So if you have an employee that files an EEOC charge and you become aware of it and you retaliate by changing their shift or changing their job, that could be considered a retaliatory practice. And so you've got to be cautious in that arena. Now, equal employment opportunity concepts. We talked about business necessity. We talked about the BFOQ. We talked about the burden of proof, the prima facie, and factual evidence. Retaliation, punitive actions taken by employers against an individual, or to prevent charges of retaliation. You need to at least try. Your organization should have an anti-retaliation policy. You need to disseminate that. You need to train your supervisors. You need to review performance evaluation data to make sure that punitive action isn't happening to your employees who have filed complaints. You need to conduct a thorough internal investigation, and you take appropriate action. Now let's jump to the Civil Rights Act of 1964, which also got amended in 1991. And the Civil Rights Act makes it illegal for employers to fail or refuse to hire or discharge any individual, discriminate with respect to compensation, terms, conditions, or privileges of employment because of race, color, religion, sex, or national origin, limit, segregate, or classify employees or applicants for employment in any way that would deprive an individual of employment opportunities, adversely affect an employee because of his or her race, color, religion, sex, and national origin. So Abercrombie and Fitch just settled for a lot of money because they were depriving individuals that didn't look American from being out on the sales floor. So they were depriving them of employment opportunities or potential promotions. So that is really a very serious violation of the Civil Rights Act of 1964. Now, it covers private employers of 15 or more, all educational institutions, public and private, state and local governments, public and private employment agencies, labor unions with 15 or more members, joint labor management committees for apprentice and training. Now, as I said, the Civil Rights Act of 1964 got amended in 1991. And it requires employers to show that an employment practice is job-related for the position and is consistent with business necessity. It creates provisions to claim compensatory and punitive damages for victims of intentional discrimination. So, you've got to be really, really cautious. It also, by the way, in 1991, a key provision was that it relates to how U.S. EEO laws are applied globally. So if you've got an employee that is working in Brazil, he or she is still bound by the laws here for sexual harassment, race, discrimination, any of that. Now, executive orders. Executive orders are issued by the United States President, and they affect employment practices for only federal contractors and subcontractors. So the President does not need Congress to pass a law. Laws are different than executive orders. Executive orders can be done by the President of the United States, and that affects federal contractors. So our President has just passed the minimum wage of $10.10 to federal contractors and subcontractors. These executive orders require affirmative action to compensate for historical discrimination against women, minorities, and handicapped individuals. And it requires affirmative action, proactive employment practices to make up for discrimination against women and minorities. So how do you do that? Well, contractors and subcontractors need to write an affirmative action plan, and that is a document reporting on the composition of the employer's workforce. So this is required of federal contractors. And they need to have objectives that to have the company's workforce demographics reflect as closely as possible the demographics in the labor market for which the workers are recruited. This is a very big plan, usually over about 100 pages and very detailed. But the OFCCP monitors it, the Office of Federal Contract Compliance, and it is extremely important for federal contractors to do it because if they don't, they lose their contract. So, managing racial and ethnic discrimination. You really need to use anonymous application procedures. Things that don't have dates on them, that don't ask for ethnicity or race or, sex. Really not having dates for things. It's really important. Adopt policies against harassment of any type, like ethnic jokes, vulgar epithets, racial slurs, physical actions. Now, let's talk about sex-gender discrimination. So we have the Pregnancy Discrimination Act, which is treating maternity leave the same as other personal or medical leaves. We just had a recent case where a Texas employer found out that one of his employees had had an abortion, and she sued under the Pregnancy Discrimination Act because it says treating maternity leave the same as other personal or medical leaves. So she was fired from her job because she had a medical condition, which was an abortion, and he fired her. So that employer had to really pay some money for violating the law. Family Medical Leave Act gives up to 12 weeks of unpaid family leave and allowing the individual to return to work. So family medical leave is things like taking care of yourself or a family member, which is really important. If somebody's got chemotherapy they're taking, they can take day at a time leave so that they can take care of themselves. And the Equal Pay Act, paying similar wage rates for similar work without regard to gender. Differences in pay between men and women are permitted when there is a difference in seniority, performance, and working conditions. All right, we have pay equity. The Equal Pay Act of 1963 requires employers to pay the similar wage rates for similar work. The idea that pay for jobs requiring comparable levels of knowledge, skill, and ability should be similar even if actual duties differ differently, significantly. It's called comparable worth. And the reason for enforcement is continued gap between the earnings of men and women. Women in 2010 were making 80 cents on every dollar of the average man, and back in the 60s it was 60 cents. So ladies, we have made a stride, but we still are struggling on pay. So steps to reduce pay inequities include all benefits that are part of pay to calculate total compensation, ensure that people know how the pay practices work, base pay on the value of jobs and performance, benchmark against local and national markets to make pay structures competitive, and then conduct frequent audits, as I said in Chapter 2. All right, glass ceiling. What is the glass ceiling? Well, just think of you as a woman sitting in your office. You look up and you see the C-suite, and there's the glass ceiling. You can see it, but you can't break through it. That is the theory behind glass ceiling. Discriminatory practices that have prevented women and minorities from advancing to the executive level jobs. Glass walls, limits that keep women from progressing only in certain fields. So women not getting into engineering, but they're kept in operations, is maybe a glass wall. Breaking the glass is establishing, the best practices are really establishing formal mentoring programs, provide opportunities for career rotation, increase the membership of women and individuals of color in top management, establish clear goals for retention and progression of women and minorities, and allow for alternative work arrangements for employees. I worked for a company that when I came into the organization as being a minority female, they tapped me as a high potential, and they wanted me to break the glass ceiling and become a director and a vice president. And they established a formal mentoring program where I was given a mentor who was actually a CIO, and I was a manager. So he was up the ranks very high. And he really coached me about the culture. He coached me about the career opportunities and the rotation I should do. He gave me very specific things to work on during my presentations. I mean, he really did coach me, and it ended up to be a very positive thing because I was later promoted from manager to director and then eventually vice president. So these programs do work, and many companies partake in them. All right, sexual orientation. First of all, there's no federal law prohibiting discrimination on the basis of sexual harassment, sexual orientation, although I do know that it is one of President Obama's intents. 18 states have passed laws to protect discrimination on the basis of sexual orientation, such as California and New York. Sex discrimination under Title VII applies to a person's gender at birth and not to new gender as a result of sex transformation operations. Nepotism at work. Many employers have policies about nepotism or prohibit them. It's the practice of allowing relatives to work for the same employer. Most companies don't like nepotism, so they restrict or prohibit it. Workplace romance is happening a lot with Gen Yers coming into the workplace. They're very open to workplace romance, and it could be very difficult for employers to state they don't want people dating at work because of potential sexual harassment. So, many companies put in the love contract, which is something that the two entering parties or the two parties enter into while they are dating. So, employers' response influences employees' and applicants' perceptions of fairness, so you have to be careful. And the HR perspective, it's risky and have great potential for causing conflict. All right, sexual harassment. Actions that are sexually directed are unwanted and subject the worker to adverse employment conditions or create a hostile work environment. And they can occur between a boss and a subordinate, among coworkers, and non-employees who have business contacts with employees. And I think a lot of people forget that, is it can be a customer, it can be a vendor. So it does not have to occur just in the workplace, the physical workplace. Now, what are the sexual harassment types? There's called quid pro quo, which is this for that, and hostile environment. Quid pro quo is perpetuated by the employee's superior. So, if you don't go out with me, I will reduce your hours. I will make your life miserable. Those kinds of things. Employment decisions hinge on whether an employee provides sexual favors, like promotions. The boss won't give a promotion unless the employee sleeps with him or her. And the company is always liable with the quid pro quo. Under hostile work environment, and these are the majority of the claims, it is really perpetrated by employees superior, but it can be coworkers and third parties. So, it is something that is, employees who make sexual jokes to other employees, who do sexting and texting, those kinds of things. Not just the boss, but the coworkers, and third parties can be customers. Pervasive, it has to be pervasive, unwanted sexual comments, pictures, jokes, and other derogatory events that create a dysfunctional workplace and don't allow the employee to perform. And the company may be liable if it cannot offer an affirmative defense. So how do we prevent it? Prevent sexual harassment. We establish a sexual harassment policy. We communicate the policy regularly. We train employees and managers on avoiding sexual harassment, and we investigate and take action when complaints are voiced. And I'm sure many of you have gone through sexual harassment training. Disability discrimination. It first started with the Rehabilitation Act, which provided for equal employment opportunity for disabled workers and applicants. And then we received the Americans with Disabilities Act, which is now enforced by the EEOC. And it applies to private employers, employment agencies, and labor unions with 15 or more employees. It was amended in 2008, which establishes a very low threshold for establishing whether an individual is disabled. So, disability discrimination. Disabled person, someone who has a physical or mental impairment that substantially limits a major life activity. And that can be things like bipolar, autism, as well as physical. But mental impairments are really the growing impairments that we're seeing. They have to have a record of such impairments, so medical documentation that they've had the impairment and that it affects their major life activities. And if you regard them as having such an impairment. So if you feel like somebody is, bipolar and you don't know it, but you regard them as bipolar, that could be considered disability discrimination because you have regarded them to have such an impairment. Disability discrimination, like I talked about, mental and psychological disorders. Employees who develop disabilities, you can shift to jobs where their disabilities do not affect them much. ADA and job requirements. Well, we've got the essential functions of the job, and these are fundamental job duties that every job has. And if you have the essential functions of the job documented and somebody has a disability and they come to you with that disability, then a reasonable accommodation can be made, which is a modification to a job or work environment that gives the qualified individual an equal employment opportunity to perform. This figure 3.6 is telling you what determines if a job function is essential. If the function may be essential because the reason the position exists is to perform that function. The function may be essential because there is a limited number of employees available who can perform the function, and the function may be highly specialized. Evidence for whether a particular function is essential is if the employer's judgment as to which functions are essential. So those are essential functions of the job. Written job descriptions are prepared. The amount of time spent on the job performing the function. The consequences of not requiring the incumbent to perform the function. If it's part of collective bargaining agreement, work experience of the past incumbents, and the current work experience of incumbents to similar jobs. So it's highly technical, and your book gives you a lot more detail than the slides. I highly recommend that you read it. Now, common means for reasonable accommodations. Well, we can modify work schedules. We can give them special equipment. We can job restructure. We can reassign them, job reassignment. We can provide them employer-provided assistance and additional training time. Those are all reasonable accommodations that the EEOC says that we're able to do when we have an individual who has a disability. Undue hardship. All right, the only defense that a company can provide is an undue hardship, which is significant difficulty or expense imposed on an employer in making an accommodation for individuals with a disability. And so you've really got to handle this on a case-by-case basis. The EEOC really looks at the financial wherewithal of the company and makes sure that the company really could have made the accommodation and they had the finances. General guidelines are provided by the ADA. It's determined, like I said, on a case-by-case basis. So, ADA guidelines to facilitate job accommodation. Well, we define the essential functions in advance. We handle all requests for accommodations properly. We work with the HR staff to explore various options for the accommodation. We interact with the employee with good faith and documentation, and that is called the interactive process. and know and follow the reasonable accommodation rules. ADA has restrictions and medical information, so let's talk about the restrictions. It prohibits employers from rejecting individuals because of a disability. Asking job applicants any question about current or past medical history cannot be done until a conditional job offer is made. So genetic bias regulations have really come to the forefront. It's called GINA, the Genetic Information Non-Discrimination Act, but employers use genetic screening tests to make workers aware of genetic problems, terminate employees who may make extensive use of health benefits. So that's why we have now the GINA law, which limits the use of genetic information by health insurance plans and prohibits employment discrimination on the basis of genetic information. Age discrimination laws. So we've got the Age Discrimination in Employment Act that was passed in 1967 and amended in 78 and 86. It prohibits discrimination against all individuals age 40 or older working for employers having 20 or more workers. The Older Worker Benefit Protection Act, and we talked about this in the previous chapter. It's an amendment to the ADEA, and it protects employees when they sign liability waivers for age discrimination in exchange for severance packages. And that again is that we have to give them 45 days to review their severance package agreement. Managing age discrimination. Well, we've got to adopt age-neutral selection and promotion practices. We've got to recruit older people to return to the workforce through the use of part-time and other attractive scheduling options. Phased retirement. Employees gradually reduce their workloads and pay level. Now let's jump to religion and spirituality in the workplace. This is also a growing area. Religious discrimination is hostile remarks or refusal to hire individuals from different faiths. And after 9/11, we really became what they'd call Islamophobia, hatred or fear of Muslims. I mean, we have 1 million Muslims in the United States workforce. Many of them are well educated and financially well off, and really they have experienced some real adverse employment action after 9/11. And so we really need to try to maybe bring Muslim affinity groups together to talk about business issues and break down the mistrust that employees may have. Managing religious diversity. Changing an employee's job task. If somebody needs to do that, we can change their job task. Making an exception to dress and grooming rules. Accommodations relating to payment of union dues and agency fees, and accommodating prayer and other forms of religious expression. All right, Immigration and Reform Act of 1986. This is your I-9s, and it requires employers to verify the employment status of all employees without any discrimination. Within the first 3 days of employment, each employee must complete an employment eligibility verification, the I-9, and there is a new I-9 that came out last year. It verifies employment eligibility of employees, and these are the primary documents that certify I-9. You should not ask for any of these documents. You just provide the list, and the employee or the applicant gives you whatever documentation they deem necessary. So, List A, passport, certificate of U.S. citizenship, certificate of nationalization, unexpired foreign passport, and permanent resident card. All that can be done on List A, or you can have one from B and one from C. Language issues. Well, this is a big one also now in the United States as our diversity of workforce continues. So speak only English at certain times or in certain situations can be done, but the organization must state that it's a business necessity of the requirements and must be justified. So it's extremely important that the organizations show a business necessity when they're implementing English only. The Uniform Service Employment and Reemployment Rights Act, USERRA, it gives basically opportunities for our military to, and military includes National Guards, individuals that have leaves. They give leaves of absences. This gives reemployment rights, prompt reemployment on return, protection from discharge and retaliation, health insurance, and continued seniority rights. So it's extremely important now that our military is coming back from war that we understand the USERRA provisions in detail. Appearance and weight discrimination. Employers are allowed to set uniform dress codes and appearance standards. Height and weight related job requirements must be job related. Diversity training. These are the components of a good diversity training program, making sure that we teach our managers and employees legal awareness and all the laws that we just reviewed. And then cultural awareness. It's a hope of understanding the differences among people and training participants to see and accept the differences in people and their varying cultural backgrounds. Sensitivity training, sensitizing people to the differences among them and how their words and behaviors are seen by others. There's been mixed results for diversity training. It may not produce long-term changes in people's attitudes and behaviors towards others. It has not reduced discrimination claims and harassment claims. Perceived as benefiting only women and racial minorities. So taking away opportunities for men and non-minorities, it's also perceived that that has happened. So how do we improve diversity training efforts? Well, we need to focus on the behavior. What is the behavior and that we are trying to really value as important. Teaching appropriate behaviors and skills in relationships to others. And dealing with diversity is not about what people can and can't say. It's about inclusion. It really needs to be considered more of inclusion. It is about being respectful to others and including all individuals in the workforce. So I hope you have found this webinar helpful. As always, please post your questions on the discussion board. Thank you for attending today's webinar.